Je vais profiter de...
Ladies and gentlemen, I'm going to use this moment. I'm going to use this moment by way of a prelude to our first round table. I'll use this opportunity to briefly speak about this afternoon. This afternoon, we'll be talking about the humanization of international law. And there's a key element which may not be in the program as such, but the key point is that the Academy itself is also humanized. It is a gift provided by human beings, and without those human beings, without those individuals, none of this would be possible. The summer courses wouldn't be what they are. The winter course wouldn't be what it is. These are very important people. I'd like to mention them. Tamara Rake, first of all. Tamara Rake, thank you so much. Maybe I could ask you to come up here. You're going to get a small gift, and you'll be carrying it around all day. It comes from the bottom of our heart. Sabine Amiel, may I call you up as well, because I would like to pay tribute to you. Verti Berger. Verti, who is over there in the usual colors. You can see them very clearly. Marina von Nico, of course. Marina.
Vanina Guénier.
Vanina Guénier. And Rula Uman. Marula is always there. If you need accommodation in The Hague, Marula is the one who looks after you. And, of course, Anna Vassilieva, who really has organized all of this so very professionally and with such calm and serenity. Thank you so much, and all my praise to you, Anna. Thank you. Do take some photographs, but then we will also let you go because we need to move on to our discussions. And thank you, Chair, for being kind enough to let me speak briefly on those points. And over to you. Thank you.
Thank you very much, Mr. Secretary General. Of course, I agreed, because these ladies certainly deserve public recognition for all the devotion and hard work in preparing, from organization point of view, this colloquium. So, grand merci à eux. As it was announced, this afternoon panel should address the issue of humanization of public international law through its rules. Certainly international law has changed in 100 years. And I'm pretty sure that my distinguished panelists will illustrate that eloquently. We are lucky that we have not only 4 great academics, professors of international law, but also practitioners, at least 2 judges, another judge ad hoc, and an arbitrator, in addition to practicing as barrister. So let's go straight to the topic. The general overview will be provided by Professor Philippe Sands. He does not need any long introduction. May I just say that I consider him the best storyteller among international lawyers. He has the ability to address large audience, large public, through his books on international law matters, but in a way which is understandable to the general public. I would just mention his books like Lawless World, Torture Team, East-West Street, Red Line, and the latest, The Last Colony. So, Philippe, may I ask you to take the floor and provide, I hope, what is to be a challenging overview of this issue of humanization of international law.
Thank you, Mr. President. Merci, Monsieur le Président, et mes grands remerciements pour commencer.
Thank you very much, Chair, and thank you to the Academy. It is a great, immense pleasure to be here again.
Privilege of giving one of the short lecture courses. It was an exhilarating experience, and in part, it was the sheer quality of the students, the most human and humane group you could imagine, and extraordinarily diverse. It was a real privilege. It's been interesting also on the subject of humans to compare the two photographs that were in the pamphlet that was distributed yesterday to see who was here in 1923. I did actually count the 7 women and the total absence, for example, of any black person, as compared with the group that was here 2022 in the summer, which was a demonstration of the journey that the Academy has taken over the last century. My experience here was a direct connection with part of the humans that make up the family of international law. So I've been asked to talk about the humanization of public international law. It's not an immediately apparent topic. It could be interpreted in many different ways. I did consult quite widely, and the consensus in the end was that I should focus on how the rules of public international law offer a place for the human. And there is, as I'm going to explain, I think something of a transformation taking place, but also something of a struggle and a battle about the place of the human in the making of the rules of public international law. The simple starting point is the human has always been a part of international public law. The Secretary-General, in his brief words, made essentially the same point that I make. It is not a fact, however, that has been easily articulated. When I went to law school in the very late 1970s and early 1980s, a wonderful law school with the most wonderful teachers, the common theme was that international law is about states, is by states, and is for states. That was what I learned. And the place of the human was literally never touched on. With the great Robbie Jennings, my first lecturer, I think we might have had half a lecture on the subject of human rights, which was probably a reflection not of a position he took, but of the generation that he came from. We are all prone to take the matters that we imbued in our first years in a particular subject and then run with that model. So the human, having been pretty much excluded, was a context that ran head on into the own reality of what I experienced as I came into the world of public international law as a student, as a teacher, as a practitioner, and as a writer. My own experience over 40 years offered a very different impression and pointed to a very large gap between the world of public international law rules as it is presented, the theory, and the world of public international law as I encountered it, the reality. The place of the human is everywhere. The teacher and the student, the practitioner and the judge, the diplomat and the civil servant, the newspaper reporter and the member of the public, all of them in different ways holders of rights and responsibilities. The themes that had been shared with me about the state being the epicenter was, I think, not accurate and not without a misleading sentiment. To take a number of examples, and I thank the President for his very kind introduction. No state invented the concept of genocide. A human being invented that concept. He was called Raphael Lemkin. No state came up with the idea of putting the concept of crimes against humanity into international law in the summer of 1945 in Cranmer Road in Cambridge. A human being had that idea. His name was Hirsch Lauterpacht, and he first persuaded another human being, Robert Jackson, to take it to another group of human beings, Soviet prosecutor, French prosecutor, British prosecutor, and to run with the idea. Of course, they needed to get the states to stamp their approval to these ideas, but the human was the beating heart. of the origin. No state came up with the idea in 1945 of crimes against peace. A very fine Soviet jurist came up with that idea, Aaron Trainin, and he went through the same exercise of persuading other human beings around a table in a small room in London about the merits of that idea. I listened this morning with great interest, as always, to Judge Charlesworth. No state ruled that Ethiopia and Liberia had no legal standing to sue South Africa before the International Court for the practice of apartheid and discrimination in relation to the black inhabitants of the territory that used to be known as Southwest Africa. A human being made that decision. His name was Percy Spender. He happened to be a judge, nominated by a state and then elected into office by other states. But in the exercise of his intellectual functions, as for any judge, judges are human, they're not automatons, he exercised critical intellectual functions of his own. And so that's the theme that I encountered very early on, the human side of how international law works and functions in practice. The theory, not the reality, not the theory. And what I've come to understand more recently, and there was a critical moment when this happened in 2003 on a march in central London against the war in Iraq, was literally 2 million people holding placards mostly made at home with various parts of the United Nations Charter written onto them in expressing their objection. And that was the moment that I came to realize that actually international law resonates very powerfully with ordinary members of the public around the world, in every part of the world. They are interested in international law. And at that point, the direction of my writing, that Peter Tomka has so kindly referred to, changed direction. I wanted to find a way to speak to those humans, participants in the international legal order, in their own way. So the human has long been in the rules. Go back pre-1945, you find rules about women employed in the night, child labourers, pirates, slave owners, civilians in war, the Kaiser said to have engaged in illegal acts. There's nothing new about the idea of the human being at the beating heart. But something changed in 1945, and it was, I have come to appreciate, a completely revolutionary moment. Many people were involved in that revolutionary moment, one that found inscription in a document called the Charter of the United Nations, but in other documents, including the Statute of the Nuremberg Tribunal. The change that took place at that moment reflected a change in the rules of public international law, one that explicitly articulated a place for the human. And one human being played a particular role in effecting that change. And his name was Hirsch Lauterpacht. In 1943, at a conference in London organized by the Grotius Society, he declared he was writing a book on the idea of human rights, and I quote, "The individual human being is the ultimate unit of all law." He took that idea forward, he promoted it. It was introduced into his work on an International Bill of Rights of Man in 1945. It was introduced into the pleadings that he wrote for the opening and closing arguments of Hartley Shawcross, the British prosecutor. And then he came to The Hague in 1947, and he gave, and I express my gratitude to Peter Tomka for reminding me, the first set of lectures after the war on this theme. And his lectures are devoted to this theme. This articulates, in a sense, the way in which the Academy's function has been to contribute to the transformation of the international legal order. Read his 1947 lecture. It is remarkably modern. It is an extraordinary piece of writing. Changes in the matter of subjects of international law have occurred in relation to rights and duties. In relation to the rights, they've included in the sphere of the recognition of the individual the growing sentiment of the worth and the status of the individual as the ultimate unit of all law, the realization of the dangers besetting international peace as a result of the denial by absolutist and totalitarian states of fundamental human rights. And it goes on. But he also looks at the other side of the story. It's not just that individuals have rights. Individuals, humans, he always focuses on individuals, doesn't use the phrase humans, also have duties. And of course, he plays an absolutely central role in catalyzing the idea of modern international criminal law, as he wrote in the pleading for Hartley-Shawcross. States don't commit murder or crimes against humanity. Individuals do. The accent was put on the human. And he concluded, an international law which leaves these facts out of its accounts will be artificial. Now, the word human allows us to reference a tension that exists. Each of us is both an individual and a member of a group. In both aspects, we have human elements. And the tension and debate between Hersch-Lauterpacht and Raphael Lemkin, Crimes Against Humanity, Genocide, is essentially about how the rules of public international law focus on the human. For Lauterpacht, the focus had to be on the human as an individual. For Lemkin, it was on the human as a member of a group. It's a fundamental difference, and one that goes back in time, including, for example, to the work of Johann Sebastian Bach and the Matthäus Passion. If you look at the lyrics of that extraordinary piece of music, you'll see it's exactly the same tension. Who are we? And international law now engages with that debate, which is continuing and which is not over. That struggle, when we talk about the humanization of the rules of public international law, there is no agreement on what humanization means. There is a big debate. Lemkin's view was that humans get mistreated and should be protected, and they get mistreated because they happen to be a member of a group that is hated at a particular moment in time. If you want to protect the human, protect the group. No, says Lauterpacht, that's wrong. If you move to the protection of groups, you will replace the tyranny of the state with the tyranny of the group. And I think there is much merit to that view, whilst also understanding Lemkin's conception of the fundamental place of the human as a member of a group. On rights, I think Judge Motoc will talk about what the developments have been in relation to the ideas of human rights. I would simply say that the developments that took place in 1945 led to a transformation in the way in which we deal with the practice of international law also. I think back to that moment in September 2018 in the proceedings on Chagos, when a video was portrayed giving a witness statement by a lady called Lisby Elise. The idea that a human's voice that had been excluded from decision-making in 1965 could be heard in the court in 2018 is a reflection of that transformation that has taken place. Look at the proceedings in relation to Southwest Africa, again referenced by Judge Charlesworth in 1966. You won't find any voices of the human being put before the court at that particular point. It reflects the change that is taking place and which is continuing. And I want to reference also the statement this morning by Makan Mbenge, the way in which the human has been excluded from the articulation of the rules in relation to investor-state arbitration, something that I live with, as Judge Tomka has mentioned. And I'd cite in particular one example of that in a dissenting opinion I wrote in Bear Creek versus Peru in relation to the place of an indigenous peoples community in the decision-making process, in which I was in a minority view as compared to my two distinguished arbitrators. But essentially it was the same issue. What is the place of the human in the rules relating to investor-state arbitration? In relation to responsibilities too, there is a struggle taking place. Let me give one example, very current right now. Nuremberg was a huge moment. I've mentioned Aaron Training's role in putting the concept of crimes against peace into the Nuremberg Statute. He was an individual human who did that, who persuaded the others. That idea grew, and crimes against peace morphed into the crime of aggression. The crime of aggression then sort of went to sleep for about 50 years, and then it came whizzing back in 1998 in Rome and was introduced into the Rome Statute with a big caveat. Okay, we'll put the idea that the human is responsible for waging an illegal war into the statute, but we won't yet give the court the power to exercise jurisdiction over that human. What's actually going on here is very interesting. What's going on is that the states who are opposed to giving the court jurisdiction over that issue, in a perfectly legitimate expression of their sovereign authority, are actually saying we don't want the human involved in the story. Let's focus on the state. Let's focus on Article 2.4 of the UN Charter, and let's keep the individual perpetrator out of it. That is then taken forward in 2005 in this court's judgment in Democratic Republic of Congo versus Uganda. I was counsel for the Democratic Republic of Congo, which is essentially about Article 2.4 of the United Nations Charter, except that the DRC also invited the court to conclude that the use of force was on such a scale that it amounted to an act of aggression. The court went very far. It said that the military intervention was unlawful and was of such a magnitude and duration that the court considers it to be a grave violation of the prohibition on the use of force expressed in Article 2, paragraph 4. But it did not say it was an act of aggression. Why not? The court didn't say why not. I think we know why not. 2 years earlier, a coalition of countries had gone to war in relation to Iraq in circumstances, my view has been pretty clear about this, that were manifestly illegal. And I don't think the court wanted to add fuel to the idea that the individual humans who were behind that decision should somehow be subject to the full force of the law. I think that's what was going on. Of course, it's not articulated, it's a matter of speculation, but I think that's what happened. Then you go to the Kampala Amendment of 2010, and the same thing is taken forward in relation to keeping out. And then most interestingly, just last year, the International Law Commission excludes the crime of aggression from the list of crimes under international law of which immunity ratio in materia will not apply, Article 7 of its draft articles on immunity of officials. They don't really explain why they did that. It doesn't really make sense because they say in one part we're taking all of the crimes in Article 5 and 6 of the statute of the ICC, and then they step back. I think what is going on is this is a reflection of the struggle. Do we want the human in the rules of international law or not? We'll have them in for war crimes, we'll have them in for crimes against humanity, we'll have them in for genocide, but when it comes to an illegal war, we'll keep the human out of it and we'll just focus on the state. That's what I think is happening. It reflects a particular struggle. Just to conclude, and where this is all heading, there is, of course, another direction which seeks to replace the anthropocentric place of the human at the heart of international law with the environment. I'm talking about the idea of ecocide and placing the protection of the environment at the heart. This is based on ideas developed by an American academic in a seminal law review article in 1972, Christopher Stone. If you read one law review article in your life, read this article. Whether you agree with it or not, it is beautifully written. And it's called Should Trees Have Standing? And it posits the idea that we have become too anthropocentric, too focused on the human. Let's start focusing on giving the environment, the natural environment, rights under international law. That is, I think, the coming struggle in relation to the place of the human in the international legal order and in its rules. I think it's best that I stop there, Mr. President. I've probably exceeded my time and allow you to take over. Thank you for your patience in my excesses.
very much, Philippe. Maybe I'm not a good moderator, but your presentation was so captivating that I did not find courage to cut you short. That would have been different in the courtroom. Well, I just invite the first of the panelists, my distinguished colleague on the curatorium, Nico Schrijver, Professor Emeritus in Leiden, former member of one of the human rights committees in United Nations, I think on economic, social, and cultural rights, recently judge ad hoc in Special Chamber of Law of the Sea Tribunal, and still advising the Dutch government as a member of Council of State, in particular on legal matters and international law matters. And he's going to address the role of the United Nations in this humanization of international law. Nico, you have the floor.
Thank you, Judge Tomka. Excellencies, colleagues and friends, we, the peoples of the United Nations, these are the appealing words of, opening words of the United Nations Charter. And they were designed to mark a notable attempt of the founding fathers in 1945 to make a shift of paradigm in international law and organization. Namely, to include into national and international security of states, human security as well. And indeed, whereas the international political architecture of the 19th century Concert of Europe and the two Hague Peace Conferences here and the League of Nations, they all focused nearly exclusively on states and their interstate institutions. The newly established United Nations was aimed to pursue also a peoples-oriented approach, with full respect for the inherent human dignity and human rights. And no doubt, the horrifying atrocities of the Second World War, as so well recorded once again by Philippe Sands in his book Red Line, were at the root of this new mission. And indeed, as regards the inception of the humanization of international law, it is correct, as Philippe did, to refer to the UN Charter, the preamble, Article 1.3, Articles 55 and 66, and obviously also to the Universal Declarations of Human Rights, the Anti-Genocide Convention of '49, and the Constitution of UNESCO, to mention another example. I will discuss various strands of international law, of course all very briefly, but I believe it is only logical to mention human rights first as the supreme expression of the humanization of international law. That is the prime example. And indeed, I have exactly the same quote from Sir Hers Lauterpacht from his Hague Academy lectures here in 1947, referring to, I quote, the worth and the status of the individual as the ultimate unit of all law. And therefore, the post-1945 international law started to focus on the plight of the individual, wherever he or she may be located. And what, in my view, matters most in this respect is the instrumental role of international law and the United Nations in extending the entire human rights catalogue of human dignity, human rights, and freedom of all, a phrase in the preamble of the Charter, for the first time in world history to all human beings, whatever their race, color, sex, language, religion, and a number of other qualifications mentioned in Article 2 of the Universal Declaration. And obviously, this did not happen overnight and could only be painstakingly be achieved through a long process of standard setting. From the Universal Declaration and the Decolonization Declaration in 1960, through the Anti-Racial Discrimination Convention as the first global human rights treaty in 1965, and many treaties to follow, also for women, children, disabled people. To, indeed, the important proclamation in the Vienna Declaration of 1993 and the happy honeymoon of the post-Cold War periods, that all human rights are indivisible, interdependent, inalienable, and universal, to quote from the Vienna Declaration. And let me indeed also take up briefly the reverse side of the human rights coin. And not only states, but also individuals must observe human rights. And next to accountability of states for violations of human rights, individual criminal accountability arose, especially for international crimes of serious concern. And in this way, the humanization through the development of international criminal law is also part and parcel of humanization of international law in general, as so well coined by Judge Meron in his Hague Academy lectures of about 20 years ago. It is acknowledged that many violations of human rights are caused by the acts or omissions of other human beings. And this realization crystallized into the establishment of the post-1945 war crimes tribunals of Nuremberg and Tokyo, and the various ad hoc international criminal tribunals from the 1990s on. And the development of what you could call supranational criminal law culminated with the adoption of the Rome Statute for the International Criminal Court in 1998 and its entry into force in 2002. But we also have, talking about humanization, the responsibility to protect as a new part of the international law of peace and security. For long, a strict interpretation of the classic principles of sovereignty, non-interference in each other's internal affairs, and the prohibition to use force in interstate relations prevailed over global protection of human rights. But during the post-Cold War period, this view became qualified. Increasingly, state sovereignty was interpreted as also implying responsibility, and that the primary responsibility for the safety and well-being of the population lies indeed with the state itself, but that there is a secondary responsibility, a collective interest for the international community. In the words of the influential International Commission on Intervention and State Responsibility, this means where a population is suffering serious harm as a result of internal war, insurgency, repression, or state failure, and the state in question is unwilling or unable to hold atrocity crimes, the principle of non-intervention yields to the international responsibility to protect, unquote. And 2 years later, on the occasion of the 60th anniversary of the United Nations in 2005, the General Assembly endorsed this new doctrine of the responsibility to protect. And for reasons of time, I will not outline it. Most of you are familiar with it, but basically it means that indeed when a state is unable or unwilling to protect its population, the international community, through the United Nations, has the responsibility to help to protect populations from genocide, war crimes, ethnic cleansing, and crimes against humanity. Well, that is at best an emerging doctrine, an emerging principle of international law. Yes, it was applied in Darfur, with respect to Darfur, in the Sudan in 2005, in Libya 2010-11, in Côte d'Ivoire. But in various subsequent cases, including Syria and Mali, It could not be applied because of a paralyzed Security Council. And to take up one more example, the law of the sea and the law of the global commons, we have the concept of the common heritage of humankind and the concept of the common concern of humankind. And that was all introduced in the context of the law of the sea and the legal regime for the moon and its natural resources. And basically it is meant to replace the first come, first served principle by an international regime aimed at non-appropriation, aimed at sharing of benefits, used for peaceful purposes only, and taking into account the needs of present as well as future generations of humankind. And as such, the common heritage and also the common concern of mankind as principles are part and parcel of the humanization of international law and aimed at safeguarding and sustainable planetary management of these areas, their natural systems and natural resources beyond the limits of national jurisdiction. And there are interesting discussions also in this academy to what extent it also applies wholly or perhaps partly to resources within national jurisdiction, such as biological diversity, the climate system, tropical rainforests, and other transboundary resources. And also to conclude, like my colleague Philippe says, is humanization of international law part of an anthropogenic obsession? Indeed, the nearly exclusive focus on the interests of humankind, including in the Sustainable Development Goals, and on humanity as a global value, meets increasing criticism from movements advocating een cosmologie générale, to quote een boek by Walkenaar on cosmologie ou description générale de la Terre. And it is in a way an attack on a holistic view on nature and all species living on Mother Earth. Indeed, the trees, Julius Stone, the whales, the panda bears. And there is also a book, I found it recently when I was a few weeks ago visiting my daughter in New York City, a book, The Revolt Against Humanity, published by the Columbia University Global Reports. The Revolt Against Humanity, imagining a future without us. And indeed, that applies to all of us. Also to Professor Sens and even to the judges, Tomka, Bennouna and Motoc. Well, the impact this revolt against all of us could have on new directions in the humanization of international law, perhaps even the dehumanization of international law, is an equally fascinating as imaginative topic for further discussion and indeed speculation. But one thing I know for sure, the Hague Academy during its next 100 years will be bound to address it and will certainly do so. Thank you very much.
Thank you very much, Nico. And I now invite Judge Julia Motoc. She's Professor of International Law at the University of Bucharest, and since 2013 has been adjudicating human rights cases in European Court of Human Rights. You have the floor.
Merci beaucoup, Juge Tomka.
Thank you very much. Thank you, Judge Tomka. It's a great honor to be here. Thank you very much for inviting me. I left my country. My country, of course, had known a long history of totalitarianism, as you know. I was, in fact, part of the first generation of Romanian students who went abroad. And I actually went to see Professor Yves Daudet at the time. And I also visited the orangery of Louis XVI. This was all in Aix at the time. And it was an opportunity for me to hear about the Hague Academy. I hadn't actually known about it before, and it seemed extraordinary to me compared to what I knew from my own country, what we'd learnt in terms of international law back home. It was quite extraordinary to me. I think everyone can understand what I'm talking about here, not just at Tomka or indeed other colleagues who may have been subject to the same kind of regime. To quote Philippe Sands, a judge is not an automaton. A judge is a human being, and therefore, if I may, I would like to also speak as a human being and, in a way, answer points of international law.
Ma collègue et amie Horatia Moyvat,
like my colleague, Professor Muir, whom I no longer see, and as she mentioned beforehand. So I would like to refer to the question she mentioned regarding the issue of hospitality, and especially what she called the anthropological turn in human rights. I think it's a very interesting concept. And I see that Mr. Sands also referred to the notion of indigenous peoples in his separate opinion. So humanization of human rights, what does it mean? And when we ask this question, and I'm sure that we have received some original replies, but like all students and law professors, we must remember that this concept has become extremely important in international law and legal teachings, thanks to the course taught by Judge Debisis at the Academy of International Law, who spoke about this subject at length and also spoke about it in many writings. And he, in fact, spoke about this issue, even if the relationship between international law and this law had previously been mentioned by persons like my former colleague, Mr. Sicilianus. But Mr. Veran, in fact, wrote this book, and it became real legal teachings in international law. It was in that book that he spoke about the humanization of international law in all possible branches: economic law, international criminal law, humanitarian law. That, in fact, was his main speciality, and went on as well to speak about other parts of international law. Mr. Morang held a debate around that subject and referred to research carried out by various researchers in various branches regarding the humanization of international economic law or international criminal law, or indeed human law. Mr. Van, in fact, then was followed by the very original and philosophical work by Mr. Casado de Trinidad, who also worked on this subject. The work is so rich that it still warrants further study, even if one has studied philosophy. So what does all of this mean for the legal practice of international law? There is the broader meaning of humanization. It means that we're in fact seeking another form, another constitution in international law. And this approach, of course, is nothing new. It amounts to rewriting in 2011 everything that was written at the end of the 1990s. In other words, we're seeking a consistent, coherent order, but we're no longer saying that that is to be found in the Charter, as was said at the time, but this, in fact, takes the shape of human rights. And in human rights, we're seeking something which can serve as a basis. And for Kelsen, of course, there was also the question of jus cogens. And this is a form of humanization, which is in fact heading towards a form of constitution, reinventing the unity of international law, which previously was seen as being under threat, especially if we look at the work carried out by the ILC, which we're all familiar with. And secondly, if we look at another meaning, which I'm meant to talk about here, but of course we can't really say that subjects which are set in stone are the best, because I can't just forget my philosophical background. And if we look at humanization in semantic terms, we in fact see a form of practical humanization, which is in fact based on certain human rights treaties in various branches of law. If we take, for example, European law, our neighbours, the Court of Luxembourg, we see that cases of preliminary rulings deal more and more with human rights issues. 10% of their applications focus on human rights. And in fact, sometimes they're in fact acting even quicker than we are, the European Court of Human Rights. And this is very interesting. It was perceived in dialectical terms because we have seen not only that human rights have had an impact on international law, but equally that general international law is influencing human rights. And on several occasions, we held this debate at the European Court of Human Rights. And we see this discussed in various courts. We were able to hold a colloquy with the International Court of Justice, and we discussed these issues. We talked about the convergence between human rights and international law. So it's a question which arises especially in connection with responsibility, the problem of jurisdictions, and sometimes views differ as to whether or not there is this convergence. Usually internationalists, including the late James Crawford, wasn't very happy about the way our court had analyzed the notion of responsibility, especially in connection with Nagorno-Karabakh. So we see very different views. And if we look at another very important aspect, if we consider that human rights, in fact, are a constitution, as has been said by many scholars, how are we going to proceed with the implementation of these rights in practical terms, the implementation of treaties, the use of treaties in certain states? Is this notion just not merely theoretical rather than being a practical notion? And we see this with the spread of human rights. It's a very interesting issue. And when we look at legal writings where the theory of international relations was studies, we see various reasons put forward to understand why states ratify human rights instruments. And sometimes the ratification of these instruments is merely seen as window dressing in terms of human rights. And you know that in certain countries, certain countries which have not really evolved much in terms of upholding the rule of law, very often we do not oversee whether these instruments are being implemented properly for want of the proper bodies. And the only check which exists in those countries might be through human rights. But very often this is provocative for other countries. It's held that those countries don't comply with human rights. In any event, it's very difficult to check whether treaties are being properly applied, especially in certain areas of the world where the rule of law isn't very strong. It's very difficult to ascertain whether they are being implemented properly. A third issue I'd like to discuss when we speak about humanization and the influence of treaties is the question which we often consider, namely the difference between various human rights. Of course, erga omnes serves as a basis. There's the convention, but of course there are many other norms which have been mentioned beforehand, which can sometimes be in conflict with these basic norms. And that plays a part when we talk about the humanization of human rights and human rights provisions which are laid down in many treaties nowadays, because sometimes there can be a conflict, a contradiction between these rights. Not always, but that can happen. Previously, I spoke about the Human Rights Committee. I would now like to quote our court, the Court of Human Rights. And it should be said that sometimes we had very different views. For example, in the Conrad de Matos case, with regard to Article 6. And that's not the only difference. Sometimes there are disagreements amongst ourselves. And the Court of Luxembourg also has disagreed on several occasions when it comes to human rights. So I think that warrants reflection. So after this notion of humanization, we need to see whether there will be coherent or consistent humanization. And by way of conclusion, I shall attempt to answer what has been said. Hospitality, Derrida, in fact, bequeathed that notion to us. It, in fact, it implies that we cannot be condescending when we welcome others, foreigners, migrants, etc. We must treat them on an equal footing as ourselves. And I think that also has to be incorporated into human rights in general. And of course, this is not a recent notion, an anthropological notion. There's also the question of indigenous peoples. We've seen their pictures sometimes over here. They're wearing all leopard skins, etc. And sometimes we only concentrate on their concerns in certain areas in connection with investments, for example. But apart from that, this is very often ignored, whereas it's possibly at the very heart of this anthropological notion, which we spoke about 15 years ago, and which makes us think about other societies other than ourselves. Thank you.
Merci beaucoup pour votre présentation. Et afin de rétablir la balance.
Thank you very much. We have language balance. We have balance in every way, I would say. I would like to call now a colleague from the court, Judge Bennouna, Your Excellency.
Podium, just I mentioned, he's a former professor of international law, former dean, former judge at the Yugoslav Tribunal, former member of the International Law Commission, and former permanent in New York. Voilà, cher Mohamed, la parole.
My dear Mohamed, the floor is yours.
Security from our deliberation room. This is the judge who most frequently intervenes with philosophical consideration in otherwise rather boring technical legal discussions. Voilà.
Merci beaucoup, Peter, pour tout.
Thank you very much, Peter. Thank you for all of that. I very much hope that I can contribute something, despite everything that you've said. Contribute something today. Well, it remains to be seen. I still have to prove myself, so to speak. So first and foremost, I would like to speak to the Academy and thank the Academy of International Law. I happen to be part of its curatorium, so I'm part of the Academy. Thank you for choosing this topic by way of a celebration of our anniversary, the topic of humanization of international law. I really do welcome this opportunity to speak to this matter. I think it's important to recall, if you like, the deep root causes and the purpose also of our discipline. And for a centenary, that is very apposite indeed. Humanization of international law is something that can only develop, can only become a reality if it goes hand in hand with similar developments in domestic law. That's the gist of it, and I will revisit that point in a moment. So I'm talking about domestic law, the law within a state. Obviously, we're called upon to address both separately often. There are two fields, if you like. When it comes to the production of law, two different fields. Also for the purpose of analysis, we deal with them differently, but we do notice that there is continuity between international law and domestic law. We also know full well that a human being cannot really be just subject to the drawing of borders, if you like. There are no reserved domains, really, when it comes to human beings. And we've known that. We've known that for quite some time. I think it's part of our training, it's part of our vision, it's part of our outlook. That being said, I would like to say just a few words on this topic. Human beings form part of a natural ecosystem, natural and animal ecosystem. We're part of that ecosystem and we depend upon it for our survival. Now, Philippe Sands, Nico Schrijver, it's a pity you only spoke about this right at the end of your interventions, as if it were a detail. It seems to me that your vision is very anthropocentric at the end of the day. And yet today, how can we speak about the humanization of international law without placing the human being in a broader, more general context, the context that within which we find ourselves? Today, if we want to understand things properly, it seems to me that we need to turn towards anthropology. That's what I heard. Maybe not philosophy, but anthropology. Very well. In that case, anthropologists. How did they reach their conclusions? Well, first of all, they reached their conclusions quite some time ago. Anthropologists said that it was a mistake to put human beings at the center of everything. Levi-Strauss, in particular, I would refer you to here. Putting the human being center stage at the center of everything means that you're overemphasizing the power of the human being. It's excessive power, if you like. So in other words, in a way, it brings you back to Nietzsche and part of his more moot points, the super ego or superhuman of Nietzsche. For anthropologists, they consider that this led to totalitarian regimes and fascist regimes. That was the ultimate outcome of that kind of view. So if you put human beings at the center of everything, it means that they can do anything they like. Human beings can do anything they like. But today, I think our vision is very different indeed. We say today that human beings are not at the center of it all. Now, Nico Schrijver, you spoke about language, some that might disappear. That may be so, but I think that we need to resituate human beings in their context and resituate things in their context. That would be my starting point, if you like. Now, when I was asked to take part in this particular panel, and I was asked to think about international responsibility regarding rules, so that was my topic, so I started thinking about this. And I would say that given our professions today, we've dealt a lot with international responsibility. It's something that has exercised us often, and therefore I myself have worked on this too. I've integrated it into my work, and I feel passionately about it. Let me tell you why. Infringements of human rights and the damages that arise as a consequence of these infringements. I've given that a lot of thought. I think that I think that it's actually in the programme. We're going to speak about this later on. Diplomatic protection, for instance, the institution of diplomatic protection in terms of the scope. The scope has been extended to encompass also human rights, internationally guaranteed human rights. I'm citing the court here. The corollary being that the compensation or indemnity provided to the state is designed to repair the prejudice or damages suffered by the individual. You're compensated with a view to compensating. I refer you to the Diallo case law and the Court of Justice's ruling on that. 2007, 2012 as well. You can see that we're paying tribute to your court, Madam President. There's the substance and there's also the damages, the reparations part that I would refer you to in the Diallo case. Now, diplomatic protection, it did exercise me at one point. I gave it quite some thought. I must say, I actually drew up a report. It was a bit provocative at the time. It might not be so provocative today. But anyway, diplomatic protection is one of the means when it comes to addressing state responsibility in the event of an infringement of individual rights, but it's less and less referred to. So what are we going to talk about here? We're going to talk about disputes where states are at issue, where states are in a dispute, parties to the dispute. What are the standards that bind them? What are their responsibilities? Responsibilities that arise as a consequence of the infringement of these standards or norms. So in those situations, human beings can be the victims of serious damages because of the violation that has occurred. This can happen. So the first question that you need to ask, therefore, when talking about humanization is this. The compensation to be provided to the state, does it actually then end up with the individuals? And if so, which individuals will ultimately benefit from that compensation? A lot of judges and courts have asked about this. It's not just about applying principles. I think it's quite clear in this day and age that anyone who is a victim of an international unlawful act has rights, and these rights are enshrined in international law. That, I think, is agreed now. We're not going to discuss it any further. That is a consensus. Individuals have rights. These rights are enshrined in international human rights legislation and international humanitarian law. So, in fact, the International Law Commission said so quite clearly. There was a draft article on responsibility which they worked upon, and they said that individuals who hold certain rights shall be considered as the beneficiaries, the ultimate beneficiaries of reparations granted to the states. I'm here referring to the International Law Commission and what it had to say on the matter. So you say that, all well and good, all fine, but what about implementing it in practice? That's where things get a bit complicated, and that's where we come across some real stumbling blocks. Let me just give you an example, a flavour of what those difficulties might be. Because we have addressed this. I'm sure other judges in other courts have also addressed this. This reparation given to the state, how will it ultimately end up in the hands of the beneficiaries, the victims? The victims are the real beneficiaries, the legitimate ones. Under what circumstances will they get that reparation? How does it actually work in practice? Well, first comment I would make on that. The states, first of all, need to reach an agreement. They will agree on the amount of the reparation, and they are free to do so, and they will also agree on the way in which this amount will be distributed. This is something that they can agree amongst themselves as states. The court, when it has to settle such a problem of responsibility, when it has to rule on these matters, the court will ask the states concerned to negotiate compensation or reparation, if you prefer, and also the way in which that reparation will be passed on to the genuine victim. So in other words, there's a leeway granted to the states. They have the margin for negotiation amongst themselves. Now, the court, of course, will not actually supervise these negotiations. It's the states. The states negotiate and the states decide. Apologies, we have momentarily lost the sound. Just a moment, please.
Merci.
Thank you so much. Apologies for that, ladies and gentlemen. So, where was I? All things being equal, what will happen is that the court will ask the countries to negotiate and then to come back before it. That is how it usually works. Now, the time for negotiations can be extended and extended again. And that's actually what the court has done, because when it's asked to give an additional, to give an additional time frame within which to negotiate these things, the court will find it difficult to refuse such a request. So there are extensions, and sometimes these extensions are beyond what might be deemed reasonable. 20 years in the RDC Congo case. 20 years to negotiate something. That's very, very long. Too long. We could perhaps mention Antonio Trindade, whom we remember, and who was constantly complaining about this, saying what you're witnessing here is basically tactics, stalling tactics, delaying tactics. You're not doing anything. You're dragging your feet over this. What can we do about it? Not very much, ultimately. Anyway, 20 years. 20 years, and that's on top of the time spent at war, the duration of the conflict itself. 20 years plus, obviously it becomes very difficult to deliver justice with such a time frame. I know that a colleague here in the room has worked on this issue quite specifically, so I'm sure you suffered a lot from this. I'm sure it was very, very difficult, very, very painful to come up with some solutions that ultimately held water, if you like. So we can settle matters judicially. It's a way, in fact, of understanding all the different obstacles that a judge will come up against in these cases. For instance, when deciding on adequate reparation for the violation of international laws, even though they were established by that very same party. And the ICJ increasingly refers to the case law of regional human rights courts. For instance, yours, Madam, Mrs. Motoc, the European Court of Human Rights. That's one case law that they might refer to. They also refer to other courts and other case laws, the Inter-American Court, the African Court of Human Rights and Rights of Peoples. I know that they are developing their case law a lot at the moment, and I personally very much welcome that. And even references made to some interstate committees, committees that are drawn up on the basis of treaties which grant certain rights to individuals. That's real progress for the ICJ, because in the past the ICJ used to just dismiss, contemptuously, if I may say, dismiss completely anything that wasn't a citation of its own. It would cite itself as a court, but it wouldn't quote other courts. Now it does. Things have moved on. Now it does, and it does so quite organically, quite naturally, and it doesn't give rise to any problems. As I see it, that's a plus for the ICJ. That's a good thing. It's an achievement. What I mean by that is that it helps us guarantee the unity of international law. That approach, I think, is favourable. As for the European Court of Human Rights, it has ruled on a number of interstate disputes, because such disputes can be brought before the ECHR. And they have, for instance, had to decide on the reimbursement of persons concerned, reimbursement of the compensation originally awarded to the state. So how is that then reimbursed to the individuals? I refer you also to the case of RDC against Uganda. DRC, against Uganda. There was an issue there of compensation and how to pay that back to the victims. It was actually difficult, well nigh impossible, to actually identify the victims proper in that particular case. Hard to identify. First of all, it was very difficult to establish a causal link between the damages sustained and the internationally unlawful act, or considered unlawful according to international law. That's indeed the normal schemata within which these matters are addressed. There was also another problem with that case, the absence of evidence. In the event of an armed conflict, it's really difficult to adduce evidence, despite all the mechanisms that we have. You have to use your imagination in a way. You have to somehow overcome this obstacle and find a solution in order to gather evidence. And the DRC actually made a proposal, namely to set up a fund in order to make sure that the reparations to be paid by Uganda, that these reparations were then shared out fairly and equally between the victims to that particular conflict. I mean, it was an offer made by the country to the court, and we took that offer. We took it with both hands, and we found that very encouraging. The fund administrators adopted a number of measures, and these measures ultimately had a positive impact on all the communities affected by this conflict. For instance, the construction of clinics, etc. So this was important for individuals and also for communities. The money was used to set up clinics, schools, roads, what have you. Now, in addition to international tribunals, you can also find reparation in other fora, such as international committees or commissions that are set up specially post facto following serious violations of fundamental human rights. And according to these systems, there is a reparation mechanism that shall be deployed to that effect. I would like to quote or mention one example, because I happen to be part of that particular commission. It was a compensation commission of the United Nations. It was set up by the Security Council in 1991. It's quite an original invention, and it's a compensation commission that was deciding on reparations due by Iraq following its invasion of Kuwait. So I was part of that exercise. I can tell you one thing, at least as far as my panel was concerned, we weren't necessarily ruling on the law part. We had psychiatrists with us, psychiatrists who sat in and who explained what PTSD, post-traumatic stress disorder, what exactly that meant, PTSD. So the psychiatrists assisted us. What else did we have? We had other experts from various fields, conflict experts, evidence experts, calculation of reparations experts, etc., etc. And together, collectively, we took a decision on the awarding of reparations to the victims. I think it's also important to bear in mind something else. The action for reparation, is usually, most often, an action made to the benefit of the injured party, the injured state. The reparation is also requested, of course, by the injured state, but exceptionally, even though usually it's brought by the injured state, it might be brought by any other state if that other state feels that there's a breach of an erga omnes partes obligation. That's in the common interest of the states parties to the convention, or indeed erga omnes full stop, in the interest of all the states bound by a general customary standard or norm. And in the latter case, the erga omnes case, and this is an important point, and I'm sure that it will arise in practice going forward, we're talking about crimes, international crimes, allegedly committed by the state against its own population. We have, in fact, a case before the International Court of Justice which deals precisely with that kind of aspect. The International Law Commission, for its part, has held that in these situations, reparations shall be due either to the injured state or to the beneficiaries of the obligation concerned. And by that they mean the victims themselves, the victims who are on the territory of the state held responsible. And that is indeed the case as it applies to an erga omnes partes obligation violation, or indeed erga omnes full stop, as enshrined in many of our treaties and conventions, and the examples mentioned by Philippe Sands a moment ago. The Chair, I apologize. I admire your general course given at the Academy, not only in terms of its content, very interesting from that point of view, but also because it's so concise. I admire you when you are concise, dear colleague. I forgot to say that earlier. Oh, thank you so much, Peter. How very kind of you. How very kind of you, says Judge Bennouna. Very well. I'm coming to my final conclusion. Fear not. So, I come back to the IRC that under those circumstances, the ones I just outlined, that the compensation can also be provided directly to the victims. So, I close that point. Now, what happens? What happens in those cases? The victims turn either to the state, that's one option, or they can turn to the courts, the tribunals of that state. And in that scenario, you find this issue that comes up under domestic law. Are you actually operating in a country where there is a rule of law? Is the state governed by the rule of law? Are the tribunals and courts independent? Do they deliver justice? Yes or no? It depends upon that. So at the end of the day, what you come up against is domestic law and the rule of law, domestically speaking. That, if you like, is the gist of my argument here. We're talking here about the humanization of international law, by all means, but it has to also be accompanied by the rule of law in the countries domestically. If you don't have the rule of law domestically, then you can't have humanization internationally. That is my humble opinion. And as for the ICJ, and I will conclude on this point, it has actually had to face this question. It was a case that concerned Italian courts. Could Italian courts award reparations to Italian nationals for acts that had been committed? And that's another question that's come back. To some extent, it's been resolved, but in other regards, it comes back. And Madam President, don't worry, I'm not going to speak about the future. I'm only speaking about the past, nothing about the future. So, once again, it was about reparations to Italian nationals for acts perpetrated by the armed forces and the other bodies of the German Reich. This was during the Second World War, of course. And could that be done without taking into account the immunity enjoyed by Germany as a state? A judgment was handed down in 2012. So again, I am referring to the past. In that ruling of 2012, the ICJ held that Germany was entitled to respect for its jurisdictional immunity before the Italian courts. Therefore, the question that arises, and I put this to the students to see if they can mull it over and come up with some kind of answer. You never know. Anyway, the question that I would like to put is the following. Does respect for immunity as a prerogative of sovereignty, does that respect for immunity take precedence over the right of access to justice? That is the question. Because if that were to be the case, the individuals concerned, these were Italian nationals. They had no other remedy. They'd exhausted all other remedies. They'd even taken it to regional courts. All they had left was a remedy before their own domestic courts. That's all they had left. And let me continue with my question. Should we allow domestic courts, and I actually drafted an opinion on this, so I'm on fairly safe ground here. Could the domestic court be allowed to waive the immunity in question when the victims have no other remedies available to them before the courts of the responsible state or indeed before competent regional courts? So is immunity justified if it actually deprives you of your access to a court and if you have no other remedies available, if your only remedy is before your own court? It's an open question. It's not been resolved. There is no answer to date, far from it, but I would encourage some research into this area by putting this question. And I now come to my conclusion, Chair. The rights of victims to an effective judicial remedy, and it is the key question here, I think. Victims shall have, must have this opportunity to obtain effective judicial remedy. And that is perfectly in line with international law. And the United Nations have said this repeatedly. And from that point of view, what I note is that there is a gap, a glaring gap between the rules of international law on reparation, on the one hand, and the institutions that are mandated to implement this with some kind of effectiveness. There is clearly a seizure, a gap between the progress we've made in terms of rules and then the institutions which are lagging behind. And in this area, I would say that international justice cannot really have any real impact unless it manages to strengthen the rule of law. So, ladies and gentlemen, I hope you have understood. For me, the rule of law is king. It is absolutely salient. Thank you very much.
Monsieur le juge, qui vous remercie. Merci beaucoup. Vous pouvez certainement.
Thank you very much, sir. We can now give further thought to the points which you mentioned at the end. I believe that if we were to deal with these issues. If we were to resolve, it'll be up to your successor.
General, as a main coordinator, would allow 5 more minutes for 1 or 2 questions. But please, questions, no comments, just concise questions. And I will admire your questions as I admire conciseness of Judge Bennouna's general course. Who is asking for the floor over there, please?
Yes, would the panel be in agreement that there has been other areas of international law, like, for example, consular law, where we have witnessed in the last years a humanization of that area as well, like having individual rights as interpreted under the Vienna Convention on Consular Relations? And would you all agree that the Paris Agreement, which is a treaty that has no really mention to human rights, have paradoxically become a treaty that is being litigated widely in human rights courts, which also hints to the same idea of this humanization of treaties outside the human rights regimes?
Thank you. And 1 more question, and then we will have answers.
Okay,
and then no coffee
it's
break.
Over here.
Only after the next panel.
Over here, excuse me.
Yeah, please.
Sorry. Thank you. Very briefly, I want us to take humanization from the side of perpetrators and not from the side of the victims. My first question is, has humanization can be used as the perfect excuse for states to hide behind their own and not face consequences of their actions behind individuals, similar to what in corporations we have with the concept of the separate legal personality for parent companies to avoid the actions of subsidiaries? And the second very quick question has to do with enforcing against human individuals is much easier than enforcing against states. Is humanization reality, despite its problems, a necessity of international law to remind everyone that it's law?
Thank you very much. So, in fact, these are 4 questions. So I think it would be fair distribution if each and every member of the panel addresses 1. And I give the choice of the question to answer to mon cher Mohamed. Parce que il faut rester un bon collègue au moins.
We have to remain really good colleagues, at least until the end of our term of office. But Nico Schrijver will answer one of these questions.
That's bien apprécié, mon collègue. Let me take the first question. I fully agree with you. Whereas the Paris Agreement on climate is hardly referring to human rights. I believe in the preamble there is a reference and also a reference to human dignity. But in general terms, in that almost 50 pages, hardly. Practice has it that it is really widely referred to in human rights-related cases, both at an international level. See now also the 2 advisory requests to ITLOS and the ICJ, respectively, and also very much already in the body of jurisprudence we have from national courts, and looking into the eyes of the former president of the European Court of Human Rights. Of course, we can't wait for the outcome of, I believe, the 4 cases before the Strasbourg Human Rights Court. So I keep it concise. I agree with you, and you see that although there is maybe a very cursory reference, it can have a human rights meaning, and the same applies to the Sustainable Development Goals. There are hardly references to human rights, of course, in the explanation of SDG 16 there is, but it is used as a human rights instrument.
Merci.
Thank you. I think maybe we can hand over to the lady at the podium, and Madam Judge, you can answer as well. Thank you. Thank you very much. So again, regarding the same question, Yes, the Paris Agreement does at least have that value. And in September or October, the Grand Chamber is going to state its views in the Duarte case regarding climate change, a famous case brought before our court, whose results are being eagerly awaited by all. I was in the first formation dealing with this case. So yes, I do indeed agree with you. Now, I'm afraid I didn't quite understand the first question you asked.
It was something interesting, but I am not clear that what it was.
It was mostly, I think, to Professor Sands, to be honest.
Okay.
But basically, all I was asking is, you remember it? Okay.
So perhaps I give the floor to Philippe, because the last word is always for the judge. Yeah. You have the floor.
There's a lot that could be said about that. I just, very briefly, I just had the experience of taking a short vacation of 6 or 7 days in the state of Arizona in the United States, and I went to a town called Mexican Hat, and I saw for the first time a place called Gooseneck River. It's in a remarkable place, a river that is several hundred meters below the level where you sit, which has over 300 million years carved its way down. It was a deeply impressing experience and sort of epiphany type of moment, because I came to realize at that point, in relation to your question on the Paris Agreement and climate change, the planet is going to be fine. It will self-repair whatever we have done to it over the last 200 or 300 years. And contrary to my own previous instincts, the whole move towards the protection of the environment in international law, the Paris Agreement, climate change, which is going to be a subject that some of the judges in this room are going to have to address, it's not about saving the planet. It's about saving us. The planet will be fine. The planet will self-repair. And this, I think, is really interesting in terms of forcing us to go back to the question of who is international law for, who is it about protecting? I had started from an ecocentric approach, but I'm now coming to see that the principal purpose of the Paris Agreement and all the rules that are being put in place are about us saving ourselves from ourselves. And I fear we have now passed the point of return. I think most of the scientists I talk to say it is now too late for us to do anything meaningful. And against that background, one is bound to have a high degree of sympathy for individuals, including judges, who are forced to adjudicate upon these types of questions. It imposes a very special burden on judges. In relation to your question, I've understood your question absolutely perfectly, and I've thought about it a lot. Nuremberg was extraordinarily important. No proceeding was established to deal with the question of responsibility or wrongdoing under international law by the Third Reich. Instead, a decision was taken to focus on the responsibility of individuals, to avoid placing on the forehead of an entire country, having learned what happened at the Treaty of Versailles and the catastrophe that followed, the question of responsibility. And I've increasingly come to see that, imperfect as Nuremberg was, and we know what all the imperfections are, it was the best option at that particular time to allow countries to move out of what had been a terrible period by focusing on the responsibility of individuals. I want to be very careful what I say next, because I don't want to get into any current issues in a particular way. But right now, the debate you should be following is the debate between different categories of countries on the question of whether to create a special criminal tribunal for the crime of aggression in relation to Ukraine. There are two schools of thought in relation to the groups of countries that have essentially said the answer to that question is yes. There is one group of countries that wants a full-on international tribunal precisely in large part, to put the accent on individuals rather than an entire country. And reasonable people can agree or disagree as to the merits or demerits of that approach. The other approach, held by a smaller but more powerful group of countries, is not to go for an international tribunal, but to go for what they call an internationalized tribunal, a hybrid tribunal, knowing in a sort of poison pill type of approach that this will effectively avoid a situation in which particular individuals might come to be hauled up. And you might ask yourself, why are those countries doing that? And the answer I've already given. It's because they've got skeletons in their own closet. If you create a full-on international tribunal today in relation to one particular situation, why can't it happen tomorrow in relation to another kind of situation involving a different group of countries? And I think the answer to your question is precisely hiding behind a formulation which essentially allows the individuals who are responsible for certain things that take place to hide behind the identity of their state to avoid a situation of accountability. And I think that is a good way, in a sense, to end what I have to say, because it puts squarely on the table this crucial question of the relationship between the human and the state of which they happen to be a member, including on questions of responsibility and on other things. It's a variation on the theme of Lauterpacht versus Lemkin, the individual and the group. But that is I think you've put your finger on what I'm coming to see for me is the essential question of how we try to understand what is going on across the spectrum and develop a broader theory and understanding of what it means to focus on the human in relation to putting the emphasis on legal or natural persons other than the state. It's a fascinating question you've asked.
Thank you. Et les derniers mots.
And now I give the floor to Judge Bennouna. Thank you very much, Chairman. I have great admiration and friendship for Philippe Sands for irrational reasons. It's a question of my affection for him. But I entirely disagree with the initiatives he has tried to adopt recently for Ukraine, which I disapprove of entirely. And I understand the sentimental attachment that you have when you make your references. In fact, I was given this book in a legal bookcase, and I then said, no, I don't want to read it, although I was told that it was very readable. The problem, however, and I'll be very brief, is when this idea of an international criminal court was discussed in the 1990s, I wrote an article entitled The Creation of an International Criminal Court and State Sovereignty. We were in a world of sovereignty with the end of the Cold War, and we all believed, including Russia, which had given the green light, that we were going to emerge from the Cold War and enter into a world where we would leave sovereignty behind us. And we were wrong, because today, with the Ukraine war, we have realized that we were entirely wrong, and that the 30 years have not enabled us to go beyond the world of sovereignty. We have tried to set up an international criminal court, didn't we? And we have wanted it to try individuals. And we have wanted to enter into the most sacred sphere of the state, to hand down justice. The sovereign state was based on that idea. But of course, for that you need a consensus around this or in this community, and that we shouldn't have the International Criminal Court as it is today, that of the Europeans and the Japanese, more or less. And that is what we see in Europe, in an integrated world, but not elsewhere. Targeting people doesn't help us to solve the conflict. Not at all. Maybe it might please us, but the problem of the conflict per se, because immediately you'll encounter the problem of these two measures. There are other people who have committed acts of war, torture, crimes, and no one has asked for those people to be put on trial. Justice is only respected when it's a justice for all. But if it's justice just for a few, even within a given country, justice cannot be just kept for certain individuals. It has to be for all. So I respect the views of Philippe Sands. I've never actually had the opportunity of having a discussion with him about all of this in person, but I fully respect what he believes. I understand his motivations, absolutely. But I'm afraid I do not share the same views. Thank you. Thank you very much. I would like to thank all the panelists, the professor who made the overview, and I would now like to call on the participants of the next panel to come up here to replace us. The panel will deal with the humanization of public international law in practice, which will be presided over by Professor Jamshid Momtas. Thank you.